Hello and welcome back to the channel for more updates for today, July 15th, 2020, in the Vallow Daybell case. Mark Means filed a motion with the court yesterday in response to the new amended charges in the Madison County case. Remember, this is separate from the Fremont County case where the two conspiracy felony charges are being dealt with. Here in Madison County, we have the three new charges that were brought by Rob Wood to replace the desertion and abandonment charges that had to be dropped once the children were found. So, this is Mark Means' response. Let's read through the document and then we'll talk about what it means. It says, here comes defendant Mr. Lori Vallow, Daybell, hereafter defendant, by and through her attorney of record, Mark L. Means of Means Law Office, having submitted previous notice of appearance, requests that all filings, etc., be served on her attorney as set out above. Defendant enters a plea of not guilty to counts 1, 2, and 3 of the amended complaint filed in this matter. The defendant demands this case be set for pretrial and jury trial. Affirmative defenses. These are subject to reservation and amendment at a later time. Number 1, he asserts that the court lacks jurisdiction regarding personal jurisdiction. Number 2, the court lacks jurisdiction, subject matter jurisdiction. Number 3, improper service of process. Number 4, defendant did not knowingly violate any order. Number 5, inability to comply. Number 6, in regard to count 1 and 2 of the amended complaint, the solicitation and or resisting and or obstructing an officer is a lesser included offense of the other as they the same set of pertinent facts. Number 7, defendant expressly reserves the rights to assert additional defenses once the state has complied with the discovery requests in these cases. Number 8, defendant is in no way waiving her Fifth Amendment right against self-incrimination by assertion of any and all affirmative defenses. There's a motion for the reservation of affirmative defenses, poorly spelled though it is. Basically, the defendant asserts felony charges regarding previous bond setting were dismissed, and as such, bond should be reset to reflect the current charges evident in the newly filed amended criminal complaint. Defendant requests this court to review the applicable criteria under criminal statute and criminal rule as it pertains to bond reduction. Defendant respectfully requests oral argument on this motion before the Honorable Judge Mallard. Next, there's also a motion regarding the change of venue. Again, this is just a reservation. Comes now the defendant, now she's Mrs. Lori Vallow Daybell, by and through her attorney of record and given the very recent amendment, blah, blah, blah. The defendant reserves the right to file at a later time a motion to change venue. This really isn't anything earth-shattering. She's pleading not guilty to the 3 amended charges. Okay, that's not a surprise. She's putting forth some defenses to those charges, saying that the court lacks jurisdiction, both in personal and subject matter, improper service of process. They're saying she wasn't served properly. Like, what, because she was in jail? Or is he asserting that she wasn't served properly in Hawaii? We'll have to get into that, wait and see. I'm assuming that that's current. That's based on these current charges, because the other ones were dropped anyway. So, did she not get served properly because she was in jail? I don't think that's going to hold a lot of water. The defendant did not knowingly violate any order. Yeah, I don't think he's got a chance with that one. Inability to comply. Well, she couldn't comply with the court order to produce the children because she was in Hawaii? That doesn't work either. So I think that's just, again, another case of Mark Means throwing spaghetti at the wall to see what might stick. In number 6, he's saying that the resisting or obstructing is a lesser included offense already covered in one of the other charges, so whatever. The defendant expressly reserves the right to assert additional defenses. Okay, it's very basic, very procedural. I also think he's winging it a little bit, telling the court that they lack the jurisdiction for the personal and subject matter of those charges. It's not clear exactly what that's in regards to. Is that about the contempt of court charge? I guess we're going to have to wait for the hearing to find out exactly what that's about. The next big part of this is the bond reduction. Clearly, he wants the bond reduced. The previous charges that were dropped were felonies, so in theory, those would carry a much heavier bail. But now he's arguing, well, since these are just misdemeanors, we want the bond reduced. I don't think that's such a big deal, all right? Because, remember, there's still $1 million bond for the Fremont County charges. That's not going to change, so it's okay. Go ahead, let him argue for bond reduction. As we've seen before with Judge Mallard, we're probably not going to get too far with that, but then again, they are 3 misdemeanor charges. But even if her bond is reduced to, say, $500,000, probably doesn't have a good chance of getting that met. And even if she could meet bond for Madison County, that doesn't mean they let her out of jail. She's still going to be held in detention because of the charges in Fremont County. So it's not really that big of a deal. And the change of venue, remember here, he hasn't actually requested a change of venue. He's just reserving the right to request one at a later date. So it gives you a little peek into what his strategy might be going forward. Nothing too earth-shattering. A lot of typos and grammatical errors in this document. Mark means, bless his heart, I think he's trying hard, but I think he's in over his head. So we're going to have to see where this goes. But so far today, that's all the news I have for you. It's nothing to panic about. Everything's going to be okay. The hearing for this is supposed to be Friday morning at 10:30 Mountain Standard Time. If it is aired, if it's broadcast, I will bring it to you live. So mark down the time for that. I'm not sure it's going to be because it says it's a conference, not a hearing. I'm not sure if there's a technical difference there. But if it is broadcast, I will bring it to you live and we'll watch it and talk about it as it happens. So until then, stay safe out there and take care.